It's only myself and Craig that are allowed to be seen on video. Fortunately, we can't see all of you. You can see us. But if we do see people popping up, it might be a bit disconcerting for us if you suddenly see somebody sitting on a couch with a glass of champagne chatting to us. In fact, I did a webinar that in the past where that exactly happened. So this morning we're going to be chatting to you about a number of subjects. Unfortunately, there are time constraints with regard to the webinar. These seminars that I've done over the last couple of years usually run from 9 o'clock in the morning until about 4:30 in the afternoon with short breaks in between. So obviously you can spend more time on more topics, but we are a bit time constrained this morning. We ran a seminar yesterday as well, and it went over the 12:30 slot. So we're running this from 10 till 12:30. There will be a short break at 11 o'clock to about 11:15. Then we should end off at about 12:15 with a 15-minute gap to listen to questions that will come in. But what I'm going to do is, after the forensic aspect of the webinar this morning, I'm going to ask that some questions then be asked after that has been concluded. So that's the time frame and the housekeeping rules as far as this morning's webinar is concerned. So thank you for all joining, and we are going to, as I said, kick off with the forensic side of things. Craig is going to be chatting to us primarily. I will obviously deal with certain legal aspects, and these days forensic evidence has become very important in court trials. Some years ago, many cases were really just decided on eyewitnesses, and it was sometimes better to cross-examine an eyewitness than to cross-examine an expert dealing with a spot of blood found in a motor vehicle of the accused, and that blood is linked to the deceased. So that spot of blood could in fact be the death knell, excuse the pun, of the accused in a particular case. So it's become so important for all lawyers to be able to understand forensic evidence, to be able to really have studied it. At university, I know there are some courses, they're usually half or quarter courses dealing with forensic evidence, and I think it's time that in fact be looked at so that universities can run more intense programs dealing with forensic evidence, because it is really, particularly in criminal cases, but even in civil matters, has become so crucial these days. So you need to read up on it. You need to engage with the top forensic people to get input as to how to cross-examine, let's say, a state pathologist or a blood spatter expert relating to a particular case. And the case can just hinge on that. CCTV footage, for example, can be crucial. Tracking, phone tracking is very, very important. Motor vehicle tracking, placing a vehicle at a particular crime scene can be crucial. So how to deal with that, and possibly the flaws in the state's presentation of its evidence, where you need to engage an expert, you need to read up on the latest cases, and you also then need to be completely au fait with international aspects on forensics. So just as far as I'm concerned, I'm a legal practitioner. I specialize in criminal matters, criminal defense cases. I've actually said to the LSSA that we should put our names forward to assist the state with all these state capture cases as counsel for the state. It's something that I've looked at over a number of years, and I think it's very important because there are so many cases coming through, and I wonder whether the NPA actually has the capacity to deal with all these cases. There certainly has been a massive improvement in the NPA structure recently, but there's still a number of corrupt prosecutors who are being dealt with. Some have been fired. So that has affected the whole way the NPA is operated. So I think it's time that private legal practitioners tell everybody what their expertise is and make themselves available to assist the NPA in prosecuting matters for a particular case. This happens in the United Kingdom a lot, where you have private counsel then being appointed to assist the state in specific matters where that private counsel has got the expertise. So I'm chair of the LSSA, Law Society South Africa Criminal Law Committee. I was previously chair of the Cape Law Society as it was, and I was also counsellor at the Cape Law Society and the LSSA in the past. And I think it's very important that the LSSA structure retains its position as being very active on behalf of legal practitioners to engage with all the other role players in the criminal justice system, and also to engage with the Legal Practice Council, who are just in a regulatory position. So in other words, they're not all that interested in looking after the affairs of attorneys. They obviously have a function to play and a role to play. But, I think the LSSA is the structure that is there to be able to engage on behalf of legal practitioners and on behalf of the public. In other words, if there's a piece of legislation that comes in and it needs to be debated, I believe we have a role to play to submit and make submissions to government if there are laws that are being promulgated that are unfair. Particularly during lockdown, we've seen so many unfair laws, people being prosecuted for breaches of petty regulations. Craig, do you want to just sort of introduce yourself very briefly to all the delegates?
William, thank you very much. Obviously, I'm Craig. I'm a certified fraud examiner, certified cybercrime investigator, and I'm a forensic specialist by trade. My key areas of focus are digital forensics, social media information, WhatsApp, cellular phones, hard drives, data analysis, CCTV enhancement, and putting together all of the digital world to bring that evidence into play in an acceptable manner for the court, to strengthen both the defense and the prosecution of different cases. I have my own practice. I've been at it for, I think, far too many years, as you can see by all the gray hairs. And I'm very happy to be here to share some knowledge with you guys today and to try and help you understand a little bit more about the different technologies that we're seeing becoming prevalent over the last year and how they can assist you in your cases.
Okay, great. I think for the delegates' information, the topics that we are going to deal with, we're going to start with forensic evidence in general, and then some issues with regard to cross-examining of expert witnesses and how the court views the evidence of expert witnesses. Then we're going to deal with admission of guilt fines, become quite prevalent during lockdown, bail applications, including bail appeals, the whole issue of cannabis and the Constitutional Court ruling, and as well the promulgation of a bill dealing with cannabis and how the issues are going to be regulated with regard to cultivation and the use of cannabis. Search and seizure warrants, I think that's an important aspect, and then Section 252A trap operations. We've tried to cut down the topics and we would be focusing on these topics during this morning's webinar. So Craig's going to kick off with regard to the forensic aspect, forensic evidence, how to gather evidence and how to present that evidence from the defense side, and also how to deal with the state's evidence and be able to be au fait with all of the relevant legislation and cases and articles internationally to be able to effectively defend your client. So Craig, let's hear from you.
William, thanks very much. I'm just going to do a screen share to get to the slides quickly. And if you could just confirm for me, you should have the yellow and black slide up and running.
I see that, yes. Digital forensics.
Okay, awesome. Let's get going. Guys, thank you very much. We're going to jump straight into it today. And where we're going to start is we're going to start looking at WhatsApp forensics. WhatsApp has obviously become more and more critical in a lot of cases, both civil and criminal. The better your understanding of WhatsApp is as a tool and how it works and what can and cannot be achieved from it in a forensic perspective will hopefully help you with preparation of your matters and identifying where there may be evidence that has been overlooked, or where the desire is there to get the evidence from WhatsApp directly. Even how would you do that? What can you expect to get from that? So we're going to start with WhatsApp and a little bit of a walk through what it is and isn't. So how does WhatsApp work? Well, it's a direct messaging service where WhatsApp sits in the middle. Now, this has become really important to understand when you need to acquire WhatsApp conversations for your case in terms of what data does and doesn't potentially exist. Now, effectively, a message is sent from the sender to the WhatsApp server. When it reaches a server, it's held there intact until the recipient takes delivery of the message. It's the electronic equivalent of pass a parcel, really. Once WhatsApp has passed the message to the recipient, it no longer exists and it has no trace of it. It does not exist on the WhatsApp server. So the message does exist, though, in two places. Firstly, on the sender device, where it's stored until it's deleted, and then on the recipient's device, and again, of course, until it's deleted. Those are the only two locations where that message exists once it's been delivered. So if the sender uses the delete for all option, for example, the message is removed from the database on both devices, and it's no longer on the WhatsApp server. Now, this can be problematic where the content of the message itself is needed to support a position in court. And we're often asked to assist with subpoenaing information from WhatsApp. Now, it's quite important to know what is possible, and because of the way the technology works, what the limitations are. So what is actually available, and should you subpoena WhatsApp? Can you subpoena WhatsApp? And how would you do that? There are a couple of options that exist. The primary one that we're going to look at today is Section 205 under an MLAT. So when you're wanting to acquire the WhatsApp information and you kind of understand what you're going to get in the return and you're ready and you want to do that. A mutual legal assistance treaty exists, and that facilitates the process of exchanging the information at a law enforcement level, as long as you have the appropriate subpoena, in our case, standard Section 205, issued by one of our courts. So remember that Facebook is owned by WhatsApp, so the process is the same. A standard Section 205 subpoena issued by a South African court will do just fine. That will meet the requirements. However, the subpoena must be made out to WhatsApp, and it must clearly outline the data that's required and the importance of that data to the case itself. How does your case hinge on the data that you're requesting? The case should be very clearly and very simplistically stated. It doesn't have to be a long-winded supporting statement, and normally that's drafted by the investigating officer. And this is where things can go wrong. You must bear in mind that of primary importance, the phone number that's linked to a WhatsApp account can change. For example, my phone number right now is linked to my WhatsApp account. But if I get in an aeroplane, I go off to the United Kingdom, and tomorrow morning I pick up a local SIM card, put it in my phone, and connect to the network. WhatsApp will see that I'm now outside of South Africa, but it will allow me to keep my original number. So when you're doing a subpoena, it's critical that you use the phone number that's associated to that account and the date and time on which it was used, so that the two can be tied together. If you don't do that, the subpoena may well not be accepted and you're back to square one. So just do bear that in mind. So it's critical that your subpoena indicates the correct number, the dates on which it's used, and it must not be too broad in range. You need to explain to WhatsApp exactly what you need, why you need it, and they will return the data as long as it's within their mandate and they do have that data. Once a subpoena is signed off at court, it can be served on WhatsApp electronically. They do accept electronic service via the WhatsApp electronic portal. Now, this is also a very misunderstood mechanism. Sometimes I find that the investigating officers don't know that there is a law enforcement portal, or have never used it before. And I'm going to share the address with you as well, just so that you do have it available. Okay, so the investigating officer needs to load it on the portal, and he will have to log in using an @saps.gov.za email address. If he does not have an official SAPS email address, the subpoena will be rejected immediately. Okay. Most police stations, as you know, are very sparse on email. In fact, you're quite lucky if you find a station that's got 2 or 3 communal email addresses shared. If your investigating officer doesn't have one, he's going to have to use the communal address at that station to correspond with WhatsApp. That is the only way that they will accept it. On the screen, you'll be able to see more or less what the enforcement portal looks like and the way it uploads the data and manages the case. And you can track the progress of the subpoena through the process. It's highly advisable not to mark a request as urgent unless you have substantiated the urgency within the application. WhatsApp is fielding requests on a daily basis from around the globe in a multitude of jurisdictions and a multitude of languages. So obviously the workload is quite intensive. Now, typically a return of service will take about 2 weeks. The only things that WhatsApp as an organization will consider to be urgent would be exigent circumstances where a quantifiable emergency exists, such as a kidnapping or a bona fide missing person. Provided it fits within those 2 categories, you can subpoena WhatsApp and mark it in the subject line as exigent, and it will receive priority attention. Priority return will normally take 24 to 48 hours. So the question, of course, is, okay, you can subpoena WhatsApp. There is a process through 205. What are you going to get? What can you actually expect? Just out of interest, that's a screenshot of the Facebook law enforcement portal. As you can see, pretty much the same sort of thing. You can track and trace which subpoenas have been served, when they were served, what the return date is, and you can follow it through as you go. Oh, we've skipped a slide. Okay, as you can see from the sample on the left, the amount of data that you can get from WhatsApp is rather limited. It's not necessarily useless, but it is limited. Now, the key data that's available in here is the last IP address that was used with that handset. An IP address being the Internet Protocol address. Coupled with the exact time at which the handset used the IP address, which is also available in the subpoena and appears just below the IP address, you can use that information to track back to the actual user. Now, that IP address in turn can be tracked and identifies the handset in this example as having used by the MTN network. The service provider, MTN, can then locally be subpoenaed on the strength of the WhatsApp return data to identify the subscriber and the cellular number and even the location. I'm pretty sure you're all familiar with that process as a 205. So it's about using WhatsApp to get the data, to generate another subpoena to get further data. And overall, as you can see, the amount of data that you can get from WhatsApp is very limited. The data account was created, the IP address from which it was created. And when you take into account the time it takes to draft and get the subpoena approved and then get the data returned, only to have to do another subpoena and drill into it, it does become questionable as to how much value the data actually contributes to your case. But where a specific WhatsApp account needs to be bound to an individual in order to provide positive evidence, it could well serve that purpose.
Craig, sorry, can I just come in? I've just noted some messages that have come through. Sorry to interrupt you, where the questions have been asked whether this is a repeat of yesterday's webinar or not. It in fact is well, not word for word, but it is pretty much in the topics a repeat of yesterday's webinar, because it's based on what would have happened if the seminar was run at different centres. In other words, if it was in Midrand or in Durban or Cape Town, you would have had different delegates from those areas. So it's based on that. So I'm just sorry to interrupt like this, but
no, not at all.
It's
I do see a few familiar names in the panel here. If the majority of people have attended yesterday's session, I'm more than happy to go lateral and tackle some more interesting topics just to help everybody's understanding. If everybody here has covered yesterday's work.
Yes, no, that is fine. I've just seen 2 or 3 people saying or asking whether it's a repeat or not. In essence, it is. And the reason I've just given is this would have been a seminar that would have gone from one center to the other. So you wouldn't have had the same delegates in Johannesburg, Durban, Port Elizabeth, or Cape Town. So that's why it's that structure. But I think maybe add new things and
no. With the greatest of pleasure, I can carry on for hours. Could we get a show of hands just on the panel? How many people have seen yesterday's session? Okay, 2, 5, 7. Okay, so we've got pretty much the same people that attended yesterday's session. Okay, brilliant. Guys, if you don't mind, then what I'm going to do is I'm going to pick up from yesterday's session, and we're going to go through it in a little more depth, a little bit more detail, because the majority of people seem to have attended yesterday's.
Yes, okay. I'm happy with that. Right, so session 2, because if one goes to the topics that have been highlighted, then you will see that they are pretty much the same in each venue. So you'd have a venue. The 26th was supposed to be Cape Town, then 27 Durban, 28th Midrand. So you would have had different delegates. Okay, fine. I think
that's fine. Let me just branch off from here, and let's take a little bit of discussion, and let's also look at some more involved sort of aspects.
So I think let's go on, and you can add to it, and bearing in mind that there seem to be quite a number of delegates who attended yesterday's meeting discussion popped up here. New topics, please. Perfect. Let's
100%. Okay. So let's talk a little bit more about WhatsApp and how it can be used. If we take on from yesterday's discussions, we looked at kind of examples of how you could take photographs of the screen, augment that with a text dump of the conversation, and you could then take it a little bit further, and you could create an independent statement that's going to now augment that. We also looked at the other applications where you could do a cellular dump of the phone. let's look at what is the international standard in terms of presenting things like WhatsApp evidence. Now, we circulated and we spoke briefly about the ISO standard and the NIST standard yesterday. And these are both international standards that are applied within South Africa. Currently, one of the challenges that we have is that there is no de facto South African standard for the presentation of digital forensic evidence outside of the ISO compliance, which we do our best to adhere to. I'm going to stop that screen share quickly, and I'm just going to share to my desktop, and let's just see if we can get the document open for you. Is that legible?
Yes, for me it is.
One of the documents that has been circulating in and around South Africa in terms of digital forensics is this one, which is the ACFE draft document on digital forensic standards for practitioners in South Africa. Now, the document itself is obviously originating from the ACFE, which is a forward examination body. It's not a technical body. So it is a little bit contentious in terms of their positioning to issue a standard and the standards that they're going to apply and how they want to bring this into being. So for now, it should be just considered a discussion document. And if one reads through the document, you will get to the section that deals specifically with the ISO specifications, and ultimately the definitions of a forensic expert. And it's quite an important document to read, although it's still in its infancy and it's uncertain how it's going to be applied and whether it will be applied by the ACFE internally or whether it will be applied for further distribution and recognition. Now, the document breaks the forensic industry down into its different segments. The first responder. This is the person who physically attends the scene of a crime or is executing a court order in order to acquire evidence. And you can see already the minimum years of experience there. The requirement would be 2 years of experience and vendor-based qualifications, the ACE and the NCAS certification. Both very good, very robust certifications. From there, it's broken down into a data processor. Who has the authority and the right qualifications to be imaging a drive and creating a workable investigative image? Data recovery, well, debatable whether it should be in there. I'm going to skip over that. Then finally, you get to an analyst investigator. This is a person who's going to take the image file and drill into it for artifacts and try and stitch together the chain of evidence and put together each item, each incident as it happened and how it happened. Yesterday, we discussed, for example, the importance very briefly of the registry artifacts that can position a person behind a computer, that can show their intention in opening certain links and working with those links. That would be the role of an analyst investigator. And finally, a digital forensics practitioner who works across the field in a number of areas, from acquisition through to analysis. And he has the qualification to quantify the data that he's working with. You can see already the trend coming in for a postgrad degree or diploma, as well as vendor-based certifications. And then finally, the much vaunted digital forensic expert, which of course, as you know, is not always the easiest of things to substantiate before the court. And the recommendation there is 10 years of experience within the field, growing through the different levels, as well as certain approved qualifications and certifications. Where this becomes contentious within the industry is the vendor-specific qualifications such as SANS, GCFE, and GCFA. These qualifications are probably the top of the line in the world. They're not the easiest to attain. The level and the depth of the knowledge is really what we want in the industry. In a perfect world, I would want everybody working with digital forensic exhibits to be at SANS standard. And the SANS modules are broken down into different elements, 5S3 or 4, which deals with registry forensics, advanced Windows forensics, cellular forensics, intrusions, hacking investigations. And one of the challenges within the industry is that any one of those certifications, one of them, will cost around 250,000 Rand to acquire. They are not cheap. It is very expensive learning, hence why we see so few people in South Africa holding those certifications, and the majority of those that do come out of a state environment, the Hawks, for example, where they've been put on those courses, the state has paid for their training, and then, of course, shortly after, they're gobbled up into the private sector. But in terms of industry, this is where we want to go with experts. This is the type and the level of knowledge and experience that we want to bring to the legal fraternity to acquire a standardization. While this document is still in its infancy, I think the period for comments on the document have already closed. But it is well worth reading through in order to gain a broader understanding of where the industry is headed, where you will find experts, and the level of experience and exposure that those experts should have. It goes all the way through to a forensic data analyst, and it does delve into the capacity and infrastructure. Now, this is an area that I'd like to just chat about a little bit, and we can always throw it open to questioning later. Is that finding a digital forensic expert is one thing, but what is their capacity? Do they have a lab facility? Do they have all the necessary controls in place for the management of that lab facility, the safeguarding of exhibits while they're in their custody? Do they have the necessary tools to do the job? Now, why this becomes important is about 18 months ago, I was asked to offer an opinion on a matter, and I was provided the documentation from the expert. And one of the things that struck me as rather odd in that particular expert's documentation was the date. The date that was displayed on the software when it generated the printout seemed to be a little bit older than the date of the report, in that I could see the logo of the company who manufactured that software. I know it had changed in the last few years. And after delving into it a little bit, I found that the software that was being used to generate the report on the artifacts was out of date by 3 years. It hadn't been updated. Now, that already gives me cause for concern as to the veracity of that evidence, because the software tool that's being used to do the analysis is not current. And if it's not current, it could be missing pieces of evidence that have happened in updates to the software subsequently. There could be bug fixes that were applied that would make a difference to the way the data is displayed. When I took the image file provided and I processed it through the same software, but with the current software updates, I achieved a totally different result to their expert. And in that particular case, the result actually differed significantly in favor of the client. So it's very important to note that whichever service provider that you're going to engage with as an expert, that the forensic software and tools that they're using are current and up to date and accepted within the market. I've seen attorneys that with the best of intentions have acquired a forensic image of a cell phone, but the image has been done with a $50 tool that can be downloaded as freeware off the internet and is actually meant as an investigative tool, not a forensic tool. So when you're engaging with the expert around these issues, much as we discussed things like Cellebrite yesterday and the way as a market leader it works with data, there are other tools. You need to be questioning what tool is your provider going to be using, and is the tool current and up to date, and can they substantiate that, because it could get called into question when you want to lead their evidence. So important takeaway there from this document, and wherever this document may end up and wherever the industry may take us, it's quite important to just follow it every now and then from a legal perspective and look at what are the requirements industry regard as an expert. What levels of experience do they need, and what type of training is going to be accepted over and above the ISO standard as it's applied. This document I believe I have, but I will send it to Amakalani as well, just so that we can circulate, make sure that you do have it. Please do give it a read through. The next one that I want to look at, give me one moment, and I'm just going to stop the share for a moment and I'll locate it for you. It should have been in your document packs. And you should have the cybercrimes and cybersecurity bill in front of you, which very briefly in the process yesterday I discussed. Now, yesterday we looked at WhatsApp. We looked at WhatsApp with metadata, the way it works with metadata. We looked at different ways that you can provide it into evidence. Let's talk a little bit about how do you prosecute that? Can you prosecute it civilly and criminally? Well, at the moment, most of the cases that involve WhatsApp would either be criminal, civil, and they're going to rely on the ECT Act quite heavily. And they're probably also going to rely on the Prevention of Harassment Act, for example, 2015, where you can show harassment via tools such as WhatsApp. The good news, of course, is that it's starting to take a little bit more structure. And the Cybercrimes and Cybersecurity Bill is, with a little bit of luck, going to be implemented by early next year, as we discussed. And I just want to take you through some of the really key areas of that bill. The first one being cyber extortion, which is section 10. I'll just skip through there for you. Okay, so cyber extortion. What is cyber extortion? Any person who unlawfully and intentionally threatens to commit offence or commits offence contemplated in the sections for the purpose of obtaining an advantage from another person or compelling another person to perform or abstain from any act. Now, that's quite a key area, and on a monthly basis, we will deal with, just in our practice, at least 5 incidences of people that would have received a Facebook friend request from someone they don't know. They engage with the person over Facebook, they start a discussion, they get to know each other a little bit, and as soon as possible, that person moves the conversation over to WhatsApp. Once the conversation is moved on to WhatsApp, they'll push and promote to move the conversation to adult content as quickly as possible, to try and exchange a couple of interesting selfies, if you will. The minute the photographs are exchanged, the extortion begins. And it starts with a small amount. Typically, they're going to start with, okay, I know who your wife is, your girlfriend, I know who your colleagues are, or for your Facebook page. I'm just going to need 2,000 Rand. Send it to me via e-wallet or via Spar Money voucher. This goes away, you'll never hear from me again. If the person complies and they pay, well, then the demands get bigger. 2,000 becomes 5,000, 5,000 becomes 10. We've had a matter where it went as far as 20,000 before the victims came to us to look for some sort of assistance, and we could help them resolve the matter. That is a typical example of cyber extortion. There are a number of different models in play of how this is done. But that's the key one. And at the moment, it's a bit of an issue because we have to, how do you process it? If the person wants to go forth and lay a criminal charge, who do they charge? What do they charge? Normally that would fall under just a plain charge of extortion. And the elements of crime can be a little bit difficult to prove within the area of using WhatsApp specifically. So the new bill creates cyber extortion as an element of its own that can be pursued in terms of the bill. And it really will help us to reduce the number of incidences within that area. In any given month, as I say, we're dealing with about 5, but I would say that we know of 3 active syndicates around South Africa that have yet to be identified, but they all have the same hallmarks. The pattern of engagement is the same. It's a copy and paste of the threatening text. So we can tie them back to individual syndicates. And they are working up quite a storm. Typically, the victims don't want to come forward and lay a complaint or create a criminal charge because they don't want their spouse or their colleagues to find out about the matter. It does become a bit of an issue. We've seen this happen to a very unfortunate family during late 2019, where their 16-year-old son was being cyber bullied or cyber extorted in this fashion. And being a school kid, he didn't have the money to pay them. And no matter how much he pleaded in his text, the barrage of what they were going to do and who they were going to tell became relentless, to the point that the child eventually attempted to commit suicide. Luckily, unsuccessfully. But that is how far these things can go. And we really do need things like the cyber bill to get the teeth to pursue these properly in court. I want to have a look at another part of the Act very briefly. Okay, the attempting, conspiring, aiding, abetting, inducing, inciting, instigating, etc., commanding or procuring to commit offence. This is going to be an area that we'll have to see as it grows and as the bill is implemented, but it really is going to help us in terms of organized cybercrime, where we're dealing with syndicates that are perpetrating advanced fee fraud on a large scale, where they're using electronic means to commit electronic crimes, and they're working in pockets, where if you look at a advanced fee fraud, for example, one pocket is responsible for acquiring the bank accounts through which the funds are going to be laundered. Another pocket is responsible for creating the website. So while they create these fictitious websites offering products that don't exist, they are not deriving a direct financial benefit from a transaction over the site. You might even say, but they're innocent parties, they're just web designers. But when you can show the collusion and that they're only creating illegitimate websites, this section of the Act is going to help us to prosecute that and to really do some damage to the syndicates that are out there. If we look at the PPE market and the number of advanced fee fraud scams that took place during the lockdown period, the amount of money lost is really quite staggering. And the trail and ability to prosecute them under the existing acts is rather limited. It's hoped that the new cybercrimes bill will give us the ability to broaden that, to understand and work with cybercrime, and to give us the teeth to actually take it to court to get good prosecutions from it. Chapter 5 does bring a couple of differences into how we work with preservation orders, who may work with preservation orders. Preservation order, for example, let's say you have a Gmail account that is central to a criminal or a civil matter, and you now want to subpoena from Gmail records of that particular thread, and you want the IP addresses involved with that account in order to tie them back to the individuals. Gmail being a wonderful way to mask yourself when you want to cause a bit of mischief and stay as anonymous as possible. The first challenge that you have is that if the person gets a Gmail account, sends a couple of anonymous emails, stir the pot a little bit, make allegations, make demands, and they then delete their account. Well, you have a very short window of opportunity. It's generally around 12 days before Gmail physically deletes that account and the data is no longer available. It's seldom going to be long enough for you to acquire a subpoena, serve it, and make sure you get the data that you need. But there is an interim step, which is the service of a preservation order. At the moment, the service of preservation order is done by court. Under the new act, it will enable, by my understanding, and again, I stand to correction here, Advocate Fick would be the right one to clarify that, but my understanding is that an attorney will be able to serve a preservation order without a warrant. It is not going to give you the data. It is merely going to instruct them to preserve it pending the service of subpoena. But it will at least obviate that 12-day period and say, right, we are going to require this data. You will store, you will hold, the subpoena will come. Then you can go through the process of serving the subpoena. If it gets there beyond the 12-day limit, it doesn't matter. The data is still there. It's ring-fenced, and you'll get a return of service. It's really, really, in digital terms, I cannot emphasize how critical this is. It's so easy to go online, to register a domain, to register a server, little bit of space, and create a completely defamatory website. And to attack somebody's character, it's absolute defamation. And within 14 days, switch it off. The virtual server is deflated. There are no backups retained because the service provider doesn't need to. And every trace of it is actually gone, apart from hopefully screenshots that you've acquired. But the real data, the IP addressing and the server logs that you need to substantiate how it was done and hopefully who did it will be gone, unless you can get in with the preservation order to insist that the information is ring-fenced pending subpoena. So while this is not in play yet, I would strongly advise that you do work through the Cybercrimes Bill and look at some of the changes that are going to be happening within the industry. One of the contentious changes here is, of course, the bill does put a rather onerous obligation on SAPS to provide more cybercrime skills, to provide specialists at station level that can engage with people in terms of cybercrime, that are familiar with the processes, with the act and the prosecution. It's going to take an enormously long time for SAPS to put together that training material, to deliver that training material, and to trickle it down to station level. And at the moment, your options are quite limited where cyber forms a part of the case, and that the cyber crimes unit is really good. They have some terrific skills, but they work on an enormous amount of pressure and a very broad caseload. Obviously, cybercrime will deal with everything from kidnapping and murder and priority crimes through to harassment, cyberbullying, cyber extortion, and it's a horrendously wide berth of skills and a large plate of work for them to be handling. So your access to them as a legal practitioner is a little bit limited. I'd like to, we've still got 10 minutes. I'd like to just not do Q&A, but I'd like to just get a bit of discussion going in terms of, let's just close this off, to get a bit of discussion going from practitioners. If you could tell me what your experience is in dealing with the cybercrimes side of SAPS, have you had interactions with them? What have your interactions been like? And how do you reach out to them where you feel their expertise is needed in a matter? Anybody that can give me a bit of guidance there? I'd just like to get a feel for your understanding of the cybercrimes unit as a whole and how one interacts with them.
Craig, can I just come in here? That's
Yes.
a very important point. And the bill, the cybercrimes bill, is extremely important, because I think many practitioners have recently, let's say the last year or two, been receiving many instructions to deal with people who are being, let's say, bullied, harassed, extorted, blackmailed in the way that you've described. And these syndicates come in and they see that as an easy route to gain money, because if somebody's engaged on some sex site with somebody else and immediately, well, I'm going to tell your wife or your family, they are under extreme pressure to pay. And obviously, once they start paying out, that just continues and continues and continues.
Correct.
Then you've got the other aspect where people are hacking your bank accounts, hacking your emails, getting personal information, and withdrawing money from your account. You also get people where you've gone and paid at a restaurant with a particular credit card, and the next day you suddenly see that, and just as well that you've got, it's been brought to your attention by way of a WhatsApp message sent by the bank, that you see all your transactions taking place in Mpumalanga when you've just used the card in Port Elizabeth. So, it kind of broadens. There's so many aspects related to this kind of extortion or utilizing your personal information, and in fact, obviously the worst, drawing money out of your bank. I mean, a client of mine who came to see me and had an Investec card, and they sent through a message to say $5,000 was being drawn from that account. So he immediately phoned his wife and said, "My dear, are you drawing money on our joint account?" She said, "Absolutely not." The bank was contacted, and in fact, it was somebody in Singapore that was accessing that account and in the process of drawing money from the account. So obviously the bank immediately noticed that and warned the card holder. But just get to the issue, and we can have a look at the questions being asked in a second. The issue of the cybercrimes unit, there's so much of this kind of crime taking place, and it's also linked to more serious incidents which may end up in somebody being murdered. So, but to build up this kind of information, which then leads to a syndicate who is set up on not only extorting somebody, but actually wiping them out, killing them. So I think they've got a lot of work, and I must say that one is normally dealing with units of the Hawks who deal with commercial crime aspects, but they're usually understaffed, and I don't think they've got the sufficient training. So I think this is a unit that needs to be expanded. I mean, it's a question of finances. Maybe we must have a look at the questions that are being asked now. Okay.
Let's have a look at some questions. Let me skip down here. Okay, is the Act an update of Act 25, 2002 ECT? It's not really an update. The ECT Act still stands. It will replace parts of it in terms of the process to acquire data and the subpoena process, but it's actually a separate act on its own, specifically to ring-fence certain cybercrimes and to start building a system that is more geared to understanding cybercrime and a legal basis on which to prosecute cybercrimes. One of the deficiencies of Act 25 is it doesn't clearly outline what is the remedy where you're in South Africa, you're a conveyancer, and a transaction is processed that you're doing the conveyancing for. The funds are supposed to be inbound to your trust account, and it gets swapped around. Somebody is in the middle and the money goes off to another bank account. And this is something that targets legal practitioners on a regular basis. But what happens where the perpetrator is outside of South Africa? Is he beyond your reach? Yes, there are ways to process and still investigate and to work with DIRCO, but it's long-winded. The Cybercrimes Bill changes that insofar as the bill is made incumbent on any South African citizen, whether their actions are originated inside South Africa or outside of South Africa, and any person perpetrating a cybercrime against a company or individual based in South Africa. So it creates quite a lot more clarity to that area. And just to sort of also tackle Damien Reddy's question on phishing scams at the same time, yes, it does. It is very specific on phishing, vishing, and whether or not it leads to a consequential loss. So if I send you a phishing mail, which would be purporting to come from the Law Society and asking you to pay your subscription for the month, whatever it may be, and you click on that, and it loads malware to your machine with the intention of accessing your machine to reverse the invoice, change the direction of payment details. It stops there. It doesn't matter what I do. It's phishing or vishing. It is therefore a crime in itself, whether it's led to a loss or not. So that's the part that I like about the bill, in that it shows that a crime has been committed, whether they have successfully acquired funds or not. Andres, we had a client whose emails were intercepted. He made a deposit to the wrong bank account. Yep. So for content. Okay, that can be an issue. Very good question, where the bank is not necessarily being as helpful as one would like in a redirection scam, where the funds are directed to another bank account. It needs to go to cybercrime. They need to deal with that. The IO may have a good understanding of that actual incident. He may indeed have the technical ability to help you there. The bank is the right place, in that ultimately they also are going to sustain a loss. Maybe not financial, but it's certainly going to be reputational. They will probably lose that client. And the banks are very well equipped, where they have their forensic departments internally to provide and cooperate with the IO. However, you are going to find, as you did there, where the bank is erring on the side of caution, and they start to think, oh, wait a minute, we could have a liability here. We're not quite sure how the person got the SMS or how they authenticated the SMS. Again, they're a private company. They have to protect the shareholder first, and they're going to hold back. The IO is going to have to drive it and insist on the information and subpoena it if necessary. Quite a popular little scam, and I'm sure you're aware of the Experian data breach a couple of months ago. And one of the reasons that that data breach is particularly damaging is the volume of data that was made available breached, and the way that data is structured is dangerous, because you can filter the data by age range. So if I'm a scammer, for example, what I'm going to do is I'm going to take that data set. I'm going to filter out everyone over the age of 65, because they may not be too technically savvy. I'm going to pick up the phone. I'm going to phone the guy and say, Mr. Engelbrecht, hi, my name's Craig. I'm from First National Bank. We've got a problem. We see a transaction that we look a little bit suspicious on your account. Can you confirm? And I'm going to read back your account number for you, because I've got it off of that data set. Yes, you're going to confirm that's your account. Okay, can you tell me, did you just spend $2,500 with this service in America? What? No, not. calm down, Mr. Engelbrecht. It's quite okay. I'm going to lodge a fraud report now to prevent them taking the funds. I'm also going to send you an SMS to confirm it. Please just read the PIN code when it SMSs you. You're now panicking. You check your phone. You just see the starter and the SMS come through and the PIN code. You read the PIN code. And what you don't realize is I've actually logged into your banking, and thank you very much. You've given me the PIN code that I need to add a beneficiary or to increase your daily limit or to change your password. So it's a little bit of social engineering, a little bit of phishing, and the ability to get breached data to give it credibility. In a case like that, you're going to find the bank is going to be very reticent to assist outside of legal process, purely because there could be a liability on their side. And they're going to need to investigate that exhaustively until they can be sure there's no liability, and then they're going to be a little bit more forthcoming. It's very much a double-edged sword, where the bank is trying to help. That's what their forensic teams are there for. They're trying to do right by their client, but they're also trying to protect the shareholder. Then on the other side, you've got cybercrimes who are interested with minimizing the loss, recovering the money if possible or part of it, and investigating to identify the perpetrator. So it's quite a fine balancing act between the parties. My general approach to that is, first things first, I go directly to the bank to which the funds were transferred, and I notify them in writing that these funds are transferred to this account under false pretenses. Hold the account. I just ask them to hold it and look at it. I'm not insisting, I'm not demanding. That is up to them. But I have put them on notice that there's a problem. Generally, I find the banks are quite cooperative because they can look at the profile of the account and see, well, hold on, this account was opened by a blue-collar worker who's never put more than 100 Rand or 200 Rand into the account every month. Suddenly, there's a 100,000 Rand deposit, and it's trying to be moved out to multiple other accounts in the same day. Balance of probability, there is a problem. We're going to hold for 24 hours and see how this plays out. So timing is really critical in these matters where your client has lost money. Get onto the bank, notify them immediately. Once they're notified, you can get hold of SAPS and you can lay a case. But just notify the bank first to try and freeze what funds are available to do a clawback. Then you can put docket in. I generally, as a rule of thumb, I prefer to help the client write the statement so all of the elements of crime are correctly laid out, so that the parties are correctly nominated and the right supporting documents are there. And then I'll go down to the station with the client and submit the docket with them to see that it is properly captured. I might even phone someone at cybercrime just to make them aware of it, depending on the amounts involved or the complexity, so that they can liaise with the investigating officer directly. It's a bit of a balancing act, and you need to work between the parties to facilitate the cooperation that we would have hoped would be there organically.
Craig, can I just come in there? I think we have to have a short break, but just on the aspect of drafting the statement. I think there's a particular significant role that legal practitioners can play to assist clients, because unfortunately, the police just don't have the capacity. You talk about the cyber crimes unit. Now, I'm aware of certain units at the Hawks who deal with, this kind of thing, but it's not like going to the police station and saying, where's your cyber crimes unit? Often the docket ends up with a normal detective who hasn't got the experience to deal with it. So I think a lawyer can assist by saying, well, this docket has to go to this particular police officer or this particular unit, and then follow the docket through and insist the docket ends up going to a prosecutor who has the necessary expertise at the commercial crimes prosecuting court, as it were, and can follow it through. Otherwise, the docket is just going to disappear. Probably that syndicate is going to pay off the police officer to make the docket disappear. So there are practical problems with ensuring that a client who is now a victim of all these cyber scams and or harassment, sees that his matter is seen to. Obviously, you can bring an application in terms of the Harassment Act to try and get an order, but then you need to know who this is and against whom the order may be, obtained. If you go to the magistrate's court and apply for an order against whoever to stop, let's say, harassing you. There are, I believe, significant practical difficulties to try and stop this kind of crime, and that's why the syndicates know they can make use of this kind of these systems to try and extort people and take money from them and or blackmail them. But could we just have a short break? I see we're already 11:10, and then we'll come back to that just to finish it off. And I have seen the delegates' comments with regard to a couple of new issues, and we will obviously not dwell on what we said last week, and I think yesterday, sorry, and we can expand on certain aspects that they've asked us to do. So I think it's going to be 15 minutes. Let's make it a 10-minute break, and then we'll come back after that. And can I ask that please all delegates' cameras to be switched off? It's only Craig and my camera that are allowed by law to be on. Okay, thank you. We'll see you in a few minutes. Can we get back online again? Craig, are you there? Hi, Craig, you're back.
Right, we're back.
Okay, thanks everybody, we're back. I noticed there were a couple of questions. I don't know if you want to just reply to the added questions that have come through, and then I can just deal with some other aspects on forensics.
Okay, let's have a quick look. We've dealt with phishing scams. The ACFE course, can anyone do it? Pretty good question. Anybody could do it. You need to either be an attorney, chartered accountant, or an accountant, or an investigator with sufficient experience to go with it. In my experience, the majority of ACFEs are either accountants or legal practitioners. The course itself and the material is suitable for both and gives you really good insight into commercial crime and how commercial crime is structured, the definitions of the different types of Ponzi schemes versus pyramid schemes, which we could see quite a lot of in South Africa, the investigative methodologies that are applied to them, and of course standards that those investigations are held to. So yes, if it is something that interests you, I would say it's certainly a very good direction to pursue. Damon, you're more than welcome to pop me a message over LinkedIn if you like, and I can guide you to the different programs that are on offer and how they work, because it can be a little bit complicated sometimes in the way that they're laid out.
Okay. Great, thanks, Craig. There were a few questions relating to cross-examination of expert witnesses. Now, I think that is obviously vital for any defense counsel. So the preparation to be able to cross-examine a pathologist or a cybercrime expert is very important. So you need to know who to engage, that it's the right person, that it's not somebody who has been declared a hostile witness or whose credibility has been torn to shreds in a previous court proceeding. Because if one looks, and at the article that I've attached, where we're in our desktop, where we, yes, dealing with our expert witnesses bias. Now, if one just opens that, this is by Henry Lamb, who was actually previously with the Legal Aid Board and has written quite a number of interesting articles, but he deals with the whole issue of expert witnesses and whether or not they are biased or unbiased. And I think that is so important that you choose the right person and somebody who has obviously the expertise and has had knowledge of going to court. In many cases that I'm aware of, the defense have called expert witnesses who do not, they might have the knowledge, but they do not have the expertise pertaining to court proceedings. So that is important, because what the witness says has to be accepted by the court if you are presenting that evidence to support your case. So a court is usually in a position of not understanding technical evidence. So it's very important that that technical evidence be presented in the correct to a court in simple language so that a court can grasp it. It's got to be to the point, and it has to deal with the issues at hand. So Laram deals with the duties and responsibility of an expert witness and lawyers. He deals with handy hints for attorneys. So ensure that the expert possesses the necessary qualifications, experience, knowledge. Do not be caught up when you've called an expert and the prosecutor, who may be very experienced in the High Court, starts tackling the expertise of the witness. So you need to get a full CV of that witness when you engage the witness before you obviously go to court. And the witness is a witness of the court at the end of the day, because the witness is there to explain the issues, not the so-called hired gun, but to explain the issues at hand and to be in simple and logical language, so that the magistrate or judge, as the case might be, can understand it. So lawyers also have a duty. They have an ethical duty to the court to make sure that the witness that is going to be called has the necessary experience and is able to deal crisply with those issues at hand. Under conclusion, Laram says, may well present temptation to lawyers to call an expert witness as a hired gun. Here an ethical duty is at war with one craving for gain. But before a lawyer is tempted, he or she should remind themselves that legal services should never become a common trade commodity. So we have an ethical duty to the court. You do not want to find yourself in a position where the court makes an adverse finding about the witness, but also makes a finding about the legal representative. So to study the law, you need to study international law, particularly with forensic evidence. See what other countries' courts say. See what articles say, but make sure those articles are not articles that have been dealt with previously in other court cases where adverse findings have been made against that particular witness and maybe the articles that have been relied on. So how do you effectively cross-examine an expert witness? Well, most of us do not have that initial training at university, and even after university or practical training, schools don't really provide that. So I think we all need to take a step up to become more acquainted with forensic evidence. So courses that need to be offered, and you have so many people out there who profess to be forensic experts. Every second police officer who is retired now becomes a forensic expert of one type or another. So you need to look around and you need to speak to other people who have the knowledge to get the right person. So you've got the evidence of the case. You've got the reports from the state's expert witness. You've studied the law. You've gone and researched articles about that particular point. the cause of death. You can see that article that is in your bundle dealing with the time of death. And those are witnesses, the authors of that book are people with massive experience. So if somebody has written a book, you contact them and say, give me information. Tell me about DNA. So you've got that information. When you walk into court and you cross-examine the state witness, you can present to them an effective cross-examination strategy. And you can obviously refer to your own witness. You have to put to the witness, the state witness, be it a pathologist or be it a blood spatter expert or a ballistics expert, because that whole case can hinge on how you deal with that witness and that witness's findings. And talk to people out there about whether that witness for the state has testified in a matter. I had a matter in High Court where the pathologist, when he got into the witness box, and there was crucial evidence about the cause of death and injuries, said he is the advocate for the dead. Well, I immediately honed in on that because clearly he was not being objective. And those are factors that you need to understand, and you've done your homework. Please, the homework is important. The way you start your cross-examination based on the homework. Putting the expert opinion of other experts to him, particularly your own expert, and going through your own expert's statement. So it is so important to have the right expert in your, as it were, in your team. You might find you have a case where you have a number of experts dealing with the matter. I had a case where we had to have a expert dealing with camera and video footage. We had to have an expert dealing with the issue of tracking, motor vehicle tracking. We had to have an expert dealing with gait, how the person walked. So all evidence there was in that case was a video of a person getting out of a motor car and going and assaulting somebody on the side of the road, kicking, and it goes off camera. Then the person gets into the motor car and drives away. So there's no proper identification of the driver of the car. So the state relied on the video footage. The state called the tracker, the car, to place it in the area. And what came out that the video footage contradicted the tracker. And in fact, at the time the video was depicting of the incident, the tracker actually placed the motor vehicle 1 kilometer away from the scene. Then there was also a gate analysis call. Gate not opening the gate. So we had to contend with that because what the state did is they had videos of the accused after the event. And as a result, they tried to link up the way that the person who got out of the motor car walked across the road, kicked the person on the other side of the road, and got back in the car to try and link that is the same person as the accused. Then there was the issue of what's called commotio cordis, the cause of death. So commotio cordis is an electric shock that somebody can receive, which immediately causes death. You could be knocked in your chest area where the heart is, very briefly, very quickly, and it could cause death. So that also came into play. This was in one case, not a whole lot of different cases. So you've got the CCTV person, you've got the gate, the walking expert, you've got the person on the tracker of the vehicle, and you've got to have someone who has knowledge of pathology and commotio cordis. I'm sure nobody has actually even heard of that terminology, but it all came together in one case. So how do you prepare for a trial like that? You make sure you choose the right people who can advise you properly, and you need to pick up on the evidence. These are issues that you are having to look at and having to try and convince the court. But the problem is, practically speaking, there are many judges and magistrates who do not understand the workings of pathology, and they just say, well, this witness for the state has been a pathologist for 50 years and always comes and tells us about the cause of death. There's no reason to dispute that evidence. And many experts for the state, I found from a practical point of view, do not concede. But I think it's important when you talk to your witness that the witness concedes on issues. Otherwise, there could be negative findings as far as the witness is concerned. That in brief as to how to prepare for cross-examination. And I see there's a question about, have you had any interesting experience with proving intention in cybercrime? Well, it is a problem, I think, for the state to prove intention, Craig, and I think you can maybe assist us in that regard. So the state has to prove intention. Well, it has to prove it's coming from whoever and that it's not somebody else that's slotted in. So I think being able to prove some of these cybercrime instances are pretty difficult. The next question, would expert evidence presented have the same strength as, well, look, the evidence, if an affidavit is presented in terms of the Criminal Procedure Act, Section 212 deals with affidavits that can be presented. Obviously, if you're contesting certain issues, that witness must be called. So my view is that one should have all the experts affidavits beforehand so that you can get to what the issue, the crisp issue is at hand, that you have an exchange, an informed exchange between experts of exactly what aspect is is in dispute. So you don't just spend hours and days cross-examining, and the state doesn't have to call witnesses presenting a great deal of evidence when there's maybe just one issue that can be put to the judge to say this is the issue at stake, and hearing different versions. And maybe if the experts get together, they all come to the same conclusion. But it's been, my experience has been difficult to get state expert witnesses sitting together with defense expert witnesses to try and come to an agreement about a particular matter. I referred yesterday to David Klatzer, and he has been instrumental in pushing in criminal matters to have expert witnesses exchanging their views on issues and coming to a decision about a particular matter at hand, to be able to present to the court and say, this is the only issue, not spending 10 days dealing with a whole lot of different experts. Craig, I don't know if you've got anything to add on that, but the proven intention in cybercrime.
William, yes, just one thing on the issue of intent. That's where it really becomes specific, and you need to make sure that the expert that you're engaging knows their way around the analysis of registry artifacts. It's not sufficient just to take a copy of a hard drive and go through what's there. You really do need to know your way through the registry in order to show the intentional steps that were followed, from logging into the computer to creating the phishing mail to going and creating the malware that's going to be embedded with it, And your expert should be able to show through the registry analysis, step by step, stage by stage, when each part of the process was created, when it was put into place. What did they do while they waited for an outcome? How is their equipment typically configured? Is it configured for normal work, or is it configured to be an offensive piece of equipment that is going to specifically be used to manipulate and exploit people's computers? So having an expert, it's key that your expert does understand all the aspects of forensic analysis and not just the investigative side.
Great. I think that probably concludes that. I think we've touched on, I think, all the significant aspects of forensic evidence. Craig, thank you very much. There's a question, understand, thank you, quite the burden placed on the prosecution. Absolutely it is, and that's what it should be, and that's why witnesses should be up to speed. You know, the cybercrime witnesses should be properly trained and have their act together. So that is where lawyers can play a role to put together for these witnesses, you know, all the background information and get our own experts in on behalf of a victim of crime, and therefore assist the state, the police, and of course prosecutors, the state, with presenting a successful prosecution. Craig, I'm not sure if you want to leave the webinar at this particular point. How are you?
William, I'm actually going to hang around for a while and follow some of the session if you don't mind, but I am going to mute my microphone and my camera and just join along as a participant.
Fine. So now let's deal with some of the aspects that I didn't deal with yesterday, and I think we've pretty much yesterday exhausted the issue of admission of guilt fines, unless somebody wants me to deal with anything specific in that regard. But I'm waiting in anticipation for the bill, which is going to hopefully restructure admission of guilt fines. It's been, I believe, it's been a long time coming, and hopefully the Minister of Justice and Constitutional Development starts moving it and places that bill in front of Parliament, and also calls on comment from all with regard to the effectiveness of the bill. You know, the bill has to be effective, leading to an act, and I'm hoping that will, in the future, alleviate a lot of the practical difficulties that we've had with the issue of admission of guilt fines. So unless there's something specific, you can maybe just send a message through. Recusal of presiding officers, I think that's something that we all need to consider. I mean, we've had it recently in the state capture inquiry, where the Honorable ex-President Zuma has, in a letter, actually, his lawyer sent through a letter to the chairperson of the inquiry, asking that the chairperson withdraw. I mean, that's a bit of an unusual way of dealing with it. You can't just send a letter to the magistrate or the judge and say, well, you know, you must now withdraw from the matter because we used to be friends and now we're not friends anymore. Actually, or maybe they are. So whatever the reason may be, you can't do it by way of written communication. So it has to be a formal application in court. So it's an application in court dealing with the reason why you want a presiding officer to withdraw. Now, you might have had a fight with that presiding officer, and this is an interesting aspect. You might have had a fight, and there might have been an exchange of words between you and the presiding officer. You would have noted recently some lawyers got into quite a dreadful spat with certain judges. And because of that, your client might feel he's not getting a fair trial. So it is a ground to bring an application to the presiding officer for them to withdraw from the matter. So what you have to look at is what is the test in this regard. So recusal of a presiding officer. So Section 13 of the Magistrates Court Act deals with it. Then we have to have a look at the Judicial Code of Conduct Act, 1999. And we have to have a look at what the test is, the test of bias. That's in the President of the Republic of South Africa versus the South African Rugby Football Union. So the test is, or the question is, whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has or will not bring an impartial mind to bear on the adjudication of the case. That is, a mind open to persuasion by the evidence and the submission of counsel. So that is basically the test, but it's in the mind of the accused person. So it's the accused who has to perceive that he's not going to get a fair trial because of the fact that the magistrate or judge is not going to be impartial, as he has to be, or she has to be. So it's not a question of the magistrate saying, oh, well, you know, I'm okay. I'm not going to be involved in this matter in a way that it's going to be perceived that I'm not objective and I'm not impartial. I give an example. For example, the accused person appeared in front of Magistrate A 3 months ago. And Magistrate A made all kinds of adverse findings about that particular person. You come to court 3 weeks later and you say to the magistrate, but hang on, you dealt with this guy, you saw his criminal record, you sentenced him to 15 years direct imprisonment, you need to withdraw because you haven't got an open mind. Magistrate says, oh, no, I don't even remember. I don't even remember about this guy. Could be anybody. I'm not even going to consider that. Now, that is the wrong approach because it's what the accused thinks. What does he think? He thinks, well, a few weeks ago, he was convicted and sentenced to this long term of imprisonment by the magistrate. The magistrate obviously knows all about it. So therefore, he's not going to get a fair trial. And in any event, even if the magistrate initially cannot remember about the specific case, he may, during the second case, become aware of it. So then he needs, well, to know that at some point during that case, the facts might come back to him about the first case. And that is going to play a role in his thinking. So it's in the mind of the accused person how he views whether he will get a fair trial or not. So I give you another practical example where an accused person was being defended by counsel. In the middle, and the accused person's defense was, I wasn't on the scene, an alibi. In the middle of the cross-examination of a state witness, the counsel for the accused turned to him and had a brief chat, then turned to the magistrate and said, listen, I just need time to come and see you in chambers, which he did. But what he did in chambers with the prosecutor present was to tell the magistrate that my client is lying to me. He told me now that he actually was there. And they went back to court, and this is what the counsel for the accused tells the accused. And the accused immediately says, well, hang on, I mean, there's something wrong here. Please, I think you need to withdraw. A new counsel appears on the next occasion and says to the magistrate, but there was this discussion in chambers, and you now know that the accused is lying because two different versions have been given to you. One that he wasn't on the scene, and now another one that he was on the scene. So you can't be objective. The magistrate, after a full-blown application for him to recuse himself, refused to do so and said, no, I'm not going to be biased. I mean, listen, let's forget all about that. I'm going to be objective about things. Matter went on review, and the High Court in the Western Cape, fronted two judges on review, said absolutely nonsense. He has to recuse himself because what is the thinking of the accused? He knows now the magistrate regards him as a liar, so he had to withdraw himself. I've found in many instances, particularly in the lower courts, where you bring an application for the recusal of a person, that the magistrate, regional or district, sort of gets upset. And this is now an attack on the magistrate. Now, surely as a judicial officer, you are trained to not regard there to be personal attacks on you unless, well, there may well be justification for that on occasions. But the mere fact that somebody asks you to recuse yourself shouldn't be seen as a personal attack on that particular magistrate. But they regard it as such, and they often loathe to recuse themselves. I don't know what your experience is, but mine has been that the perception from the bench is, well, I'm going to be objective, even if your client thinks I'm not going to be objective, and please don't attack my credibility. But that it should actually be the magistrate saying, well, I can't apply my mind to this. I mean, facts have now come out, which shouldn't have come out, and I can't apply my mind. So there are practical problems with this, but I think you need to go armed with the necessary case law and be able to argue it properly. You may even need to submit an affidavit by your client if you bring an application to that court, setting out the basis as a separate application of recusal. So in that application, you set out your client's version in the sense of how he perceives the magistrate and that he's not going to get a fair trial. And you add whatever other evidence you need to add. In fact, in that case where the magistrate found out about the two versions, I obtained a statement from his previous counsel confirming exactly what the position was and what was discussed in chambers and why that lawyer had to withdraw, because he was now sitting with two conflicting versions. Why he went to tell the magistrate, heaven alone knows. Please don't ever do that. If a conflict arises, all you do is get up in court and you tell the magistrate or the judge, I can't proceed with the matter any further. That's it. And if they ask you why, well, you can say a conflict has arisen. You do not have to give the details of the conflict. Please, please do not do so. The aspect of techniques of cross-examination, I think I've touched on that to an extent when we were chatting about forensic evidence. I think the same applies to cross-examination in general as to cross-examination of an expert witness. I mean, it's a witness, you cross-examine. So if you're cross-examining a complainant in a matter, try and get as much information about that complainant as you can. Background, maybe the complainant has been involved in other matters where the credibility of the complainant has been shot down in court, that the complainant may be somebody who's linked to some or other syndicate and has reasons to try and implicate your client in a particular matter. So that background investigation. And if you can even appoint a good investigator to go and check up on things, crime scene, go to the crime scene, take photographs, even if it's after the event, try and do it as soon as possible. Another example of where one has to do it quickly is if you're involved in a matter of culpable homicide, where there's been a motor crash, try and get, and you get instructions shortly after the accident, somebody's died, try and get there quickly, try and get photographs taken. If you can get an expert witness like Craig to go there and take photographs of the scene to be able to present to court. So do it quickly, because if you take too long, you know, the scene might change. The municipality might come and dig up the road, put up different lighting at the side of the road, where before there were no lights. Suddenly they stick up a whole lot of wonderful lights on the side of the road. So where before accident happened at night, and that means that it was very dark. When you go for an inspection in loco, when the trial starts, trial might start 3 years down the line. The lighting has completely and utterly changed. So if you've got all the footage about what the scene was like, go and try and speak to witnesses. Get there before the police does. Do it through a private investigator, or even on your own. Go around, take statements from witnesses if the police have not already got to them to take statements. And then you've got all that information. So you've built up all this excellent information to be able to one day, when the case goes to court, cross-examine. So don't just do it the night before. Think about it. Think about it months, years before, just after the incident. Then you've got all of the right information to cross-examine with. You can put to the witness, you know, when this accident happened, there were absolutely no lights. The witness says, oh, it was beautiful, perfect. But hang on, here we've got forensic evidence that was taken immediately afterwards. Here is an affidavit from our forensic witness that we'll call if necessary. What are you going to say about all of this? And of course, then you're on top of things. So you've got your evidence, you've got your information, you've done the inspection yourself. Because when you go and inspect one day with the magistrate or the judge, as I've said, things change. You're not going to have the same situation. The lighting is different. The road might be completely different. So get stuck in immediately. As a lawyer, please think ahead. Be one step ahead of the prosecution. Be one step ahead of the police. If you can't do all of this, in other words, you only get instructions quite a long time after the event, at least go and have a look at what the scene looks like just after you get instruction. So you can go and take photographs. You can get a forensic expert in to just look at the angles. Maybe somebody was shot. You need to have a look at all the aspects relating to how the shooting took place. Where was the person who was shot? Where were the witnesses? All of this kind of thing. So that is very, very, very important. I see the question is asked, are you allowed to obtain statements from witnesses prior to the police getting statements? I believe that's nothing wrong with that. The police have not engaged them. Why can you not go and speak to witnesses? I mean, whose witnesses are they? And if you are only seeking the truth, you are not acting unethically. You can go to the witness and say, listen, have the police been to you? No, they haven't. Well, would you like to just tell me what's happening? I am the lawyer for the suspect in this case, and therefore I'm coming to talk to you. Now, the question is that not regarded as construing, influencing a witness? Not at all. Don't influence the witness. Take a recording device with you. Take your phone and record. And say to the witness, I am so-and-so, I'm here just to seek the truth. Are you prepared to give a statement? You don't have to give a statement. So make it very clear that if that witness later on says you arrived there and try to threaten them and force them and blackmail them, then you've got that proof that that is not the case. But make sure that the police have not already been there. I mean, I've had a matter where this was raised, but you went to speak to the witnesses. Well, I said, but yes, but they weren't state witnesses. You've got no kind of control over everybody. Where in the law does it say you can't go and speak to somebody who's seen what has happened? You can do so. That's why it's important to get out there quickly. But if you can't get out there quickly, please try and find out who the witnesses are. And maybe there are other witnesses that the police have not gotten hold of, even if you go afterwards. So to sum up, cross-examination, it is something you can learn. Go and listen to those who are cross-examining, who are good. Go and listen to other cases as a young lawyer. And work on what's happening in court. See how somebody else presents the case. The right person, please. And then you can build up your expertise as cross-examining. But reading the books on effective techniques of cross-examination, going into court, listening to discussion groups, watching Netflix movies, all of that might help. Except I think some of the movies are probably over-dramatized. Don't watch the American ones, maybe watch the BBC, they're probably more objective. Read Rumpold of the Old Bailey, John Mortimer, amazing. This guy, well, I mean, it's a fictitious character, but all his cases, they're all in short story, and he tells the story about all his episodes with judges and his episodes in court, and his fight with his wife, she who must be obeyed, and his dealings with the jury system. So, you know, all kinds of help, it all kind of helps to be able to tune your mind into how to deal with cross-examination. But sometimes it's instinctive, and you can't be taught that. You have it in you. What happens in the middle of a court case where you suddenly have to change tack? You've had all your preparation done, every single thing. You've got the books, you've got the articles. And suddenly this witness is sly and knows where you're going, jumps one ahead of you. You have to think on your feet, as the old saying goes. If you need time, ask for time. If something goes wrong during cross-examination, you can ask for time. You might have a difficult judge. I've had many. I had one, I won't mention his name, for more than a year. It really was hectic. But you've got to keep your cool, relax. Politeness is very important in dealing with the judiciary. And just show them that you are prepared and you know the law. So in the middle of cross-examining, something is not quite right. Something changes. Say, well, could I just have an adjournment for half an hour? Or maybe if you, at 3:30 in the afternoon, think it through overnight. And it's important that you do think it through overnight and come back afresh the next day. And please do not become embarrassed in court. In other words, as you're driving home from the High Court, you think, oh my gosh, I forgot to ask that question. But if I go back the next morning and ask the judge, can I ask that question? I'm going to look like an idiot. And the judge is going to say, do you not know what you're doing? Forget it. Bring your application. If he refuses you to ask the question, and you can say that what the question was, he'll ask you and you'll say, well, that's the question. I'm sorry, it slipped my mind. We were having such a tussle in the cross-examination. If he says no, it's a ground later, possible one of a number of grounds that could be raised on appeal or on review. So do not think, well, I'm going to look bad if I come and bring that application. Because who's important? Your client. Your client must see what happens. And please don't fall asleep in court. There's the case where a counsel for one of the accused fell asleep in court. And when that accused was called to give evidence in the witness box, the prosecutor said, but hang on, your lawyer never put any of these things to the witnesses. Did you tell him that? Because prosecutors often ask that. And the accused said, yes, I did. But he didn't put it because he was sleeping. So quite embarrassing for the lawyer for the accused. But that happens. I mean, I've had instances where court interpreters have fallen asleep. And you know, the courts are so reliant on interpreters. There is a huge problem with interpreters. You have your South African language interpreters, foreign language interpreters. In the case that took me a year, we had, I think, 10 Spanish interpreters. Every time there was a problem with the interpreter, and they don't get paid properly. They had to go ask the university. And one interpreter was shouted at by the judge and burst out in tears and was crying in the passage. She was dismissed. So the issue of how evidence is presented is crucial. So if you have an interpreter, please make sure the interpreter is interpreting properly and not giving her own version. Because what comes out on the record is what is interpreted and incorrectly interpreted. Now, we can't all learn Mandarin and Igbo and Spanish and Italian and German to be able to understand what the interpreter is saying, but one must try and learn as many of the South African languages as possible. At least you can understand some of what is being said in court by the interpreter. And if there's something that's being saying that's incorrect, you have a duty to bring that under the attention of the magistrate. So just to sum up with regard to cross-examination, it's a skill that you not necessarily are taught, but you're going to pick it up and you have to work at it, and you have to be sure that you know the facts of the case and the docket. Please read the docket. I've had many lawyers come to court and they haven't read the docket. So, number one, read the docket. Chat to the expert. Look at gaps in the evidence. Is the chain of evidence there? Or is it not? Tackle it on those technical issues, but also on the factual issues, and find out as much as you can about the witness before the witness gets into the witness box. I have so what I'm dealing with now is those extra topics that I'd listed in the topics that I was going to deal with at the face-to-face seminars. So the ones I chose, which I dealt with yesterday, was for obviously the shorter version. So I'm now adding to that for the longer version, but bearing in mind that the longer version actually is also shorter than the actual longer version. So some of this I can't spend as much time on as I would have liked. The inspection in loco, let me just go back to that, because other than where you have gone and done your own inspection, let's say when you immediately get instructions or at some later time and go and check it out, if you feel it's important to ask the magistrate or the judge to go for an inspection. Now, sometimes a judge will say we've got to go for an inspection, and off you traipse to the scene of the crime, and the TV cameras are there, and everybody's like bumping into each other, and the accused is there if he is in custody with the police or correctional officers, and it can become a bit of a bun fight. But if you've gone armed with all the information beforehand, and you can point out at the inspection, because an inspection is recorded, so everybody takes notes, the prosecutor, the judge, if there are assessors, and the defense counsel, all taking notes. And then you go back to court and you record those notes to say this was said, and this was witnessed, and this is what the distances were and all of that at the inspection. So then it becomes a minute. A minute which becomes part of the court proceedings, which, if there's an appeal later, obviously is part of the court record. Please make sure it's minuted properly. So when you go back and the prosecutor says it was 5 meters and you say it was 50 meters, make sure that is resolved. So rather it's resolved at the actual scene. But if you've gone to the scene beforehand, then you are one step ahead of the prosecutor, who will, believe me, will not have gone to the scene, and of the judge, who certainly would definitely not have gone to the scene. So you can have it all then beautifully set up. If there isn't an inspection, make sure that you can present to the court, let's say, a bundle of photographs, which you give to the prosecutor beforehand, upon which you're going to rely. So the prosecutor might say, listen, I don't agree with these photographs. I've got to bring the photographer. Or they might say, I accept it. Because often you might get the evidence in the state bundle, and there are photographs in there, and there's a plan of the scene with distances and positioning and all of that. But there's nothing wrong with you going to do your own plan of the scene, and particularly relevant where you have motor car collisions, culpable homicide cases, but also any other case. I mean, it might be a drug case. It sometimes can be a bit difficult going to certain areas, let's say where a stash of drugs were found, because it could be a little bit dangerous. But so, obviously has to be cautious, and particularly if you have to go there at midnight. But if you can go to that place and you say, well, hang on, the police say they found the drugs in this room. And this isn't the room where the accused was staying. It's a room that's shared by 20 other people. Then it has a huge effect on the case. How do you deal with that? So you've got all the information, you've been there beforehand, and then you can insist that the court go for an inspection, or take photographs and present those photographs to the court. Few questions coming through, and excuse me if I just deal with these questions now, because it also does take time, and while I'm talking about it, we're all kind of, in the flow of dealing with that particular topic. How do you prove that you did not tamper with the scene or change the integrity thereof? Well, look, I think that is why it's important to try and get an expert who is going to be coming to the scene, drafting, the scene, a plan of the scene, taking photographs, putting that in a bundle, and you can call that expert later. That is really the ideal. If you can't and you can't afford it, go and still take your photographs with your cell phone, but that is what you're going to use in cross-examination. So you're not going to give evidence yourself about the photographs and the scene, but you're going to use that for cross-examination purposes. If it is necessary to then have somebody come to court to deal with the scene, distances, time, lighting, whatever, as an objective witness, then you need to get a forensic person to be able to bring that evidence to court. But that doesn't stop you dealing in cross-examination and handing up even photographs to the witness, even if the accused is saying, well, this is it, and that is his version. He can come and testify about the photographs himself, or he was present when the photographs were taken. So, you can enter that evidence later by way of calling the accused, or that the accused himself has gone to take the photographs, to get around preventing you having to call a witness. But obviously the ideal situation is get an expert, negotiate a fair fee. Craig always charges me reasonable fees, and then to put together this whole bundle to avoid problems later on. Do it in anticipation. It may not even be necessary. And you might have a situation where you are putting something to a witness and handing up a photograph, and the court might say, well, okay, I provisionally allow it. So once it's in provisionally, then you're already halfway there. Then you can use it to cross-examine the witness on. So remember, there are ways and means of dealing with this, of skinning a cat. many, many ways and means. And I suppose, you know, the longer you're in the game, well, it's not really a game, it's a profession. The longer you're in the profession, the more you learn all the skills. There's another comment here. If you're appointed as a watching brief for a complainant in matter, and you realize that the prosecutor is drunk all the time or drugs or sleeping in court, often during the case, how do you as a watching brief approach without prejudicing the state's case? What? I mean, that is shocking if that is a true story. I think that was, yeah, from John. You go and see the senior prosecutor in that court, or you go to the director of prosecution and say, listen, I'm here looking after the victim of crime, and the prosecutor is drunk, sleeping, and not doing his case. In actual fact, true incident recently where in a bail application, it was armed robbery, the whole community were up in arms and didn't want the accused to get bail. The lawyer for the victim engaged a private investigator, and they got video footage which placed the victim at the crime scene, going in and coming out. The prosecutor never used that during the proceedings. Crucial, and the guy got bail. If that was used, it would have seen that the accused potentially would not have got bail. So in that instance, the person watching brief went and spoke to the senior prosecutor, but actually after the fact, it was too late then. So that crucial evidence will have to be used in trial, but the man is out on bail, the community on up in arms. So it's unacceptable. Prosecutors don't come and tell me that you've got. We all have a lot of work, and we've got to fit it in. We have to deal with difficult clients. We have to deal with prosecutors, judges, and magistrates. And we as lawyers were not getting a set salary during the lockdown period. So prosecutors must be on top of their game as well. And as I said, in those watching briefs, maybe it's time that we all started putting forward proposals to the NPA to use private lawyers. It is possible. They can engage you, and particularly where there has been a call during all the arrests on the state capture corruption cases for people who've got expertise to come forward. We yesterday dealt with the issue of cannabis. I'm not going to go back to that. I think please read the cannabis bill. I think it's confusing, and you know, how do you get the drugs if you can't buy it from somebody, but the guy selling it to you is guilty of a crime? It's a complete runaround. While I'm on that, I managed somewhere to get. Somebody asked me yesterday for that case in Kimberley. I'm not sure if the person is a delegate today, but I can just give you the details. It's Petrus, Petrus Gelant, Gelant. He's the appellant. The matter was argued on the 12th of October this year in the Kimberley High Court, and the case number was CA&R 57 of 19. It was on the same day as two other matters that were of a similar nature. But if you go and check on that case, you'll be able to pick up the other cases. As I said, we are busy dealing. We are still waiting. We're still waiting for the decision. Just on the watching brief, behind the scenes service. Well, I think you need to be in front of the scene. I think you need to go and introduce yourself to the magistrate and say, listen, I'm Mr. So-and-so or Miss So-and-so or Mrs. So-and-so. I'm here as a watching brief. Go and sit at the front. Don't sit at the back or outside. Speak to the prosecutors beforehand. If you have to engage with the defense counsel, do so. And make sure your client, the family of the victim or the victim themselves, can see you doing a proper job. You're not in the background. You're not somewhere else. You're there. You're on top of it. If you've got statements that you've got a private investigator in to get video footage or get statements, do it, present it, play an active role in the case, because obviously at the moment, it's very difficult to get appointed as private counsel unless there's a private prosecution, but then there's got to be a nolle prosequi certificate from the Director of Prosecutions before that does take place. So that briefly, sorry, I was just jumping around a little bit. That briefly with regard to cannabis. I'm just going through the various items, the appeals. I think somebody asked on the question earlier about bail. Now, bail applications obviously take different forms in the sense if it's police bail, if it's prosecutor's bail falling within Schedule 7, that is less serious offences like theft under 30,000, fraud under 30,000, culpable homicide, assault with intent, possession of narcotics. I think some of those offences need to be extended. For example, if you are arrested for transporting abalone, the police where police can give bail, in terms of Section 59, where police rarely give bail because they say it's too serious, it doesn't fall within Schedule 7. The prosecutor says, well, sorry, it's not within my ambit. So what needs to happen is the Schedule 7 offences need to be extended. They need to be extended to allow and add another clause that cases where the prosecutor and the investigating officer decide that it's in the interest of justice or something like that can give bail. So you don't have to be stuck with that technical kind of thing. Oh, well, it's not a Schedule 7. It doesn't fall within the ambit. Speak to the police. The police say, no, we're not listening to the NPA. I mean, recently I had a matter where we got a case withdrawn. All the firearms, the NPA said to the police, to the Hawks, please give the firearms back. The Hawks said, no, we're not going to give the firearms back. So there was a fight between the NPA and the Hawks, and one had to then go to the High Court to bring an application for the firearms to be returned. So where the police don't even listen to what is being said or what is being directed by the NPA. There was a question, just to go back to cannabis, actually was the applicant. He applied to be admitted. He admitted smoking cannabis. He is arrested for heroin. He was one of the applicants in the Constitution, in the Cape case, which went to the Constitution, which led to the cannabis bill. Will such a person now be considered as a fit and proper person in terms of the new LPA? Well, I don't see why not, because it's now legal. So, if you have a glass of wine, are they going to come and say, oh no, you're not a fit and proper person to be a legal practitioner? I'm sure the majority of us are going to be struck off the books, and there will be no lawyers or very, very few lawyers around. So as long as it doesn't, my belief on this is as long as it doesn't affect his ability. So in other words, he doesn't come to court, he doesn't fall asleep like the prosecutor who's on drugs, and therefore he's doing his job properly. So and that could be the same with somebody who drinks. So, it's lawful to take alcohol, it's not lawful to take cannabis, but if that affects your ability as a lawyer, that's the problem, that's the issue. It's not the aspect relating to the substance, is how the substance affects your ability to represent clients, to deal with the courts, and all of that. There's another, hopefully that answers the question. The discussion about cannabis and fines, I lacked reception, hence missed. Is there screenshot? Well, just on the I'd had attached if you look at the information that was supplied relating to the new cannabis bill. I'm not sure if that's what the person is talking about. But if you check the new cannabis bill dealing with how possession is going to be dealt with, I'm other than dealing. Obviously, dealing still remains an offence. So the Drugs and Drug Trafficking Act and the sentence provisions remain in place. So just on the issue of bail, again, you've got your Schedule 7s, you've got your police bail, and then obviously you have your Schedule 5 and your Schedule 6s. That is why you have to be so on top of your game to present sufficient evidence to discharge the onus in the Schedule 5 and particularly in the Schedule 6. But our cases say very clearly that with Schedule 6, the courts must look at all the issues, and all the normal and usual issues have to be looked at, but they have to be looked at more carefully before bail is given in a Schedule 6 offence. So that is why it's so important, even at the beginning of a bail hearing, to make sure that it's the right schedule, because that can make all the difference. It is the difference between your client receiving bail or not receiving bail. Argue before the bail application starts. You can argue the issue of the schedule, and you must argue the issue of the schedule. If there's any doubt, sometimes magistrates rule that if there's an objection about the schedule, then that can be dealt with later. So you need to very carefully look at what is the offence and how does it fall within the ambit of Schedule 5. So if the client is out on bail or has a prior conviction for a Schedule 1 offence, is arrested again on a Schedule 1, that becomes a Schedule 5. So a 1 and a 1, I don't know who drew up these schedules, they're arithmetically shocking. A 1 and a 1 equals a 5. But have a look at it. You need to check the relevant sections. So you will see in where I have dealt with this under bail, we deal with the police bail, as I said yesterday. And if you look at the various sections dealing with bail, all the factors that are listed there, but that you need to make sure that you know what you're dealing with, because magistrates often are not aware of what the schedules are and sometimes get them wrong. So that is a crucial aspect. With regard to, I've also briefly dealt with roadblocks, drunk in charge, possession of drugs. Well, let's just stop for a moment and talk about roadblocks. Now, roadblocks have to be set up properly. So you can challenge the validity of a roadblock, as it were, and whether permission has been given for the holding of a roadblock. That's important. Within the area of the jurisdiction of that roadblock, let's say it's a Sandton police station, have the police or Metro Police, do they have permission to hold the roadblock? Number one. And how is the roadblock then set up? And why are people being stopped? Do you have the right to say, I'm not going to blow into that breathalyzer? Or don't you? And if you refuse to do that, can they charge you with anything? They can charge you if you refuse to give your blood, but you've got to get first from the car and the roadblock to where the blood is drawn. So you can say, sorry, you've got no grounds to arrest me. And the police might go ahead and arrest you. But if you start being difficult, the police are going to be difficult. So there are all these practical problems. But what has been happening is a lot of people are being stopped in Uber vehicles, not the driver, not in a roadblock. So the car's pulled over at 1 a.m. in the morning. The passengers are all hauled out. Some may be females, and males search their bags. No permission, no search warrant, no probable cause. It's happening all the time. So if a police officer sees an Uber, he can't just reasonably conclude that the people in the car have got drugs or guns or knives on them. Stop and search. Illegal. So even in a roadblock where the Uber driver is the person who is, let's say, the subject of a roadblock, not the passengers. How can they search the passengers? But that is happening. So these are aspects, ladies and gentlemen, that you can tackle, and I think you should tackle, so that it can stop this kind of search and seizure operation. I mean, yesterday we dealt with search and seizure, and in fact, one of your colleagues in the chat referred to, so can I add to there's a case of Pompo Joseph Goqwana, G-O-Q-W-A-N-A. It's a 2016 1 SACR 384, and it follows the case of Polonyfis. Interesting name, P-O-L-O-N-Y-F-I-S, 2012 1 SAR 57 SCA, dealing with the search warrants and whether or not the affidavit on which the search warrant is obtained must be given to the person who is the subject of the search. It has to be. So that person must get a warrant and the affidavit on which the warrant is based. Right, a couple of more questions here. A few police vehicles next to the road who pull off a roadblock. No. Where we are. Non-commissioned officer authorizing, here we are. Yeah, just about roadblocks and warrants, empowering the police to search a vehicle or the person. This person comes from a small town, and they then, having non-commissioned officers authorizing the search. Well, but then it doesn't matter whether they have that person there or not. You've got to follow the law. You can't change the law. And the person correctly says, bypassing the law on a technicality, giving a low-ranked police officer much more power. Precisely. You can't, that cannot be allowed. So they can't come and say, well, we don't have the necessary officials. In other words, where it has to be a police officer who authorizes a search and seizure warrant. Sorry, we don't have a police officer around the place. Let's just get a constable to authorize it. Well, that warrant is to search and seize is completely and utterly meaningless. A few police vehicles next to the road who pull off cars, is that a roadblock? No, definitely not. It's got to be properly set up. You've got to have beacons, you've got to have the necessary identifying marks, all of that kind of thing. So you can't just suddenly pull people left, right, and center off the road unless the police have probable cause. Get back to that issue, probable cause. So that is what is important. Let's go on. If the police arrest somebody because his breath smells of alcohol, is that on its own probable cause? Nothing wrong with his driving, nothing wrong with the way he talks or walks or eyes, none of that, but his breath smelt of alcohol. Well, maybe he had a drink 3 days ago, didn't brush his teeth. That is not sufficient grounds to arrest the person for driving under the influence of alcohol. So that is what is important. So, the issue of warrants, the issue of breaching people's privacy, that is completely and utterly unacceptable. And I think we need to challenge this more and more. So you've got the cases, you've got Van der Merwe, you've got Khokhwane, Polonifus. All of those cases set out the requirements that are necessary for a proper search of premises or a vehicle, and with regard to what the courts must look at, but obviously what the police must look at, and how they must apply for warrants. But they keep getting it wrong. Even an arrest without a warrant, there still has to be probable cause. A search without a warrant, the so-called warrantless search, there's got to be probable cause, reasonable suspicion that somebody has committed a crime. So the fact that somebody breath smells of alcohol, is that reasonable suspicion they've committed a crime of driving under the influence of alcohol? No. How can it be? The car's driven properly, the person is talking properly, there's no accident, there's nothing wrong with the ability of the person, he's functioning, nothing at all. So, yes, they can arrest without a warrant. Members of the public can arrest without a warrant if it happens in their presence. Search without a warrant, but then they've got to follow the requirements that there's got to be reason, because otherwise the police are going to be stopping everybody and searching everybody. So the example I gave in terms of the Uber driver incident, where they are arresting more and more people who are in the back seat. Can you imagine you in the back seat of the car and they just come and search you, even if they don't find anything? It's a massive invasion of privacy. I mean, I'd get seriously annoyed if I'm in an Uber and the police pull me off and they say they want to search me. I mean, I'll say, I'm sorry, no, you've got no reason. But then they might grab hold of you and knock you to the ground and kick you. Well, anyway, then we've got an amazing, huge claim that we can institute against the police. Just on the issue of the person smelling of alcohol, I know there's a SCA decision on that point where it was actually a police officer, but I can forward you the information later. A police officer who was arrested, and the issue was whether he had been driving under the influence. He was arrested for that. He sued the state and he actually succeeded. And it was all about the breath, alcohol on the breath aspect. And it was established by the Supreme Court of Appeal that is not, those are not grounds. So just remember that for the drink and drive stuff. Drink and drive are very interesting, fascinating cases. Chain of evidence is so important, as with all the forensic type of cases, but even more so there. The 2-hour limit, the police keep coming and saying his eyes were red and he smelt of alcohol and he stumbled out of the car, but actually, he hasn't slept for 3 days. That's why his eyes are red. He fell out of the car because he's just been involved in an accident caused by the Uber driver. And he was stumbling around because he's in a shocked state. So all of these kind of observations of the condition of a person, a driver, can be attributed to innocent things. So that is why you have to be so prepared. You're coming back again to cross-examination, even in those cases. I mean, where you put it to a witness, my client hasn't slept for 3 days. Can you dispute his eyes are red because of that? No. The alcohol on his breath, well, he hasn't brushed his teeth for 6 days. Can you dispute that? No. Fell out of the car, well, he was shocked and he's just been involved in an accident. Can you dispute that caused his reaction and his condition? No, I can't. Boom, there goes their case. Give us the time that you stopped the vehicle. Oh no, it was 25 past this and whatever. It was within 2 hours. But I mean, did you check your watch? Are you sure your watch is synchronized properly? When did you last check it? Where did you see the time? And ask for their pocketbook, because they're supposed to write in the pocketbook all these things immediately afterwards. So get these facts get hold of them, use them, and read that docket and be able to successfully defend an accused person, because the way that people are being arrested these days is actually completely out of hand. Just one aspect, and I'll leave you with this. Or is it an invasion of privacy where the police go and arrest you and they've phoned ENCA and all the radio stations in South Africa and all the newspapers to come and watch you being arrested? Can you use that to challenge the arrest? Is that not an invasion of your privacy? That's at the time of arrest. You haven't even appeared in court yet, but they've got all the cameras there. Why do the police do that? Why do the Hawks do that? They just want to make a spectacle. So aren't your rights being invaded? Let me park that question there. And there was somebody saying possibly get a copy of the recording of the webinar. Well, it is being recorded, so we'll have to chat to all the ladies from Lead. I see we've reached 12:41, and a couple of the delegates have to leave, and I know we have to cut it now. As much as I'd like to chat further, and I'm sure Lead will be arranging more webinars, and I think we need to talk more about forensic evidence. Maybe we get forensic pathologists. A few years ago, we had David Klatzer on the show, and we maybe log up with him in the United Kingdom. I think he's farming now in Wales somewhere, he tells me. But I've got to get him back to South Africa, because we're dealing with a case, and it's been going on for quite a few years. You know, they make much of it. You know, these defense counsel delay cases. Meanwhile, if you look at the facts of the case, it's actually the prosecution and maybe the magistrates who are actually delaying the case. I mean, the other day in the regional court in Paarl, I had a matter, and the state asked for a postponement, and I opposed the postponement, saying the witnesses aren't here. The magistrate had the audacity to say, because I'd arrived half an hour late, which I'd actually told them I was going to be late. Meanwhile, he'd spent 3 hours taking his son to and from school, where we couldn't get hold of him. Let's park that point there as well. But I'd like to hear your comments at some point, just with the issue of the police arriving with all of the press. And the press don't report properly. They're not reporting in an objective fashion. So, you know, that is very important. And the press call you all the time. They call you all the time. Make sure you take the calls. Make sure they report you correctly. Thank you very much, everybody. I hope everybody enjoyed it. I certainly enjoyed it. And yes, we should have some more webinars. I see there's a message here, and we can maybe look at other experts coming and chatting to us online. Or otherwise, hopefully when COVID has come and gone, we can have a meeting where everybody is present and we can engage with each other at a distance, maybe wearing a mask and spraying hands. But good luck to everybody, and any other questions, or send it through to Lead and I can possibly expand on it. But thanks to everybody at Lead. You've been amazing how you set up these webinars, and it's really is great. So thanks a lot to everybody. Okay, thank you, and cheers. Have a good day.